Good afternoon and welcome to the live session. We are awaiting some of our colleagues to join us, and we will start as soon as they're here, as well as Professor Kodia. Thank you.
Etc.
Good afternoon, Professor Korea. So we have the participants joining in, so perhaps we can start. And if you will allow, I will share the screen.
Okay.
So good afternoon, colleagues, and welcome to this live session where we will be discussing the third module of this week that many of you have already accessed. And this is on the flexibilities relating to the use of patentability criteria from a public health perspective. We have Professor Carlos Correa with us today and tomorrow to take us through a deep dive on this important topic. And if you have any questions, feel free to raise them online after after the presentation, and you can also use the chat function. And of course, subsequently later on, if you have any other questions, you're always free to use the Q&A forum on the online platform. With that, and without further ado, let me welcome Professor Correa and invite him to lead us into the presentation. Professor Correa, thank you.
Well, thank you very much. Good morning and good afternoon for those in Africa. I'm very pleased to participate, of course, in this course. I'm going to address an important issue, which is often called the most important trade flexibility in the area of patents. And this relates to
internet or why stop talking.
You have a technical problem. If you can just be with Professor Correa, are you here with us? Perhaps we have a technical problem. While you're with us, let me just quickly check on it and fix it. Thank you. Professor Correa is back with us.
I'm
yes,
very sorry.
we continue.
There was an interruption in the connection. Okay, so I was just mentioning that this is one important trade flexibility. So let's move to the first slide, please, Amalia. Next one. All right. So let me present what kind of problem this issue of patent requirements actually address. And this issue is one issue that was mentioned the opening session for this course, and you have materials on this, which is called evergreening and also the issue of patent thickets. If you look at this slide, I will read it. This is a paragraph of a report produced by a committee that was established in the US Congress in order to investigate the impact of patents in the area of pharmaceuticals. And as you can see, you can also get access to the full document, of course. you will see that the Congress got the conclusion that patents were used in the United States in order to increase in an artificially mannered prices. So this one says the committee's investigation has uncovered new evidence about the ways that drug companies exploit the use patent system and marketing exclusivities granted by the United States Food and Drug Administration to extend their market monopolies by delaying generic and biosimilar competition. These monopolies allow drug companies to raise prices without threat to their market share. Therefore, this issue is crucial when we look at the impact of intellectual property in relation to manufacturing capacities in developing countries, in particular countries that are participating in this course. Because to the extent that these practices, as described in this report, are allowed, this limit in a dramatic manner the extent to which local manufacturing can take place because generic products cannot enter the market. Next one, please. So this report found that the companies in the committee's investigation have applied for more than 1,000 patents for 12 drugs, 1,000 patents for 12 drugs, which were examined. More than 600 patents have been granted, representing a total of more than 290 years of potential patent protection. So this means that local manufacturing generic production cannot take place. This is only about 12 drugs, as you can see. This is also done in relation to other drugs. And one of the reasons why this is taking place in the United States has been observed in the literature. So many books and journal articles on this matter in the United States. And this is the fact that the patent office in the United States, although it is a very big patent office, they are very qualified patent examiners, but the patentability requirements as applied by the patent office in the United States are very low, are very lax. And then this allows for the grant of a large number of patents in the United States, unlike in other countries. So many patents that are granted in the United States are not actually granted in other countries where the patent requirements are applied in a more rigorous manner. I would not even say strict manner, I would just say rigorous, meaning that the requirements of inventive step, novelty, industrial applicability are applied in a manner that is scientifically based in relation to science, and will not allow these practices of evergreen and patent thickets. The next one, please, Maria. So one major example of this problem of evergreening is insulin. Insulin has been used therapeutically for now about 100 years. Can you expect to still have patents around insulin? Well, I think anyone would say, well, that will not be possible, for the product has been on the market for 100 years. But the reality is that there are many patents, many have been applied for, many have been granted on insulin. And this slide is taken from a report produced in Canada. This is a problem also in many developed countries, including the United States and also European countries. And as you can see on this slide, the pharmaceutical companies try to extend the effective life of their patents by making increment improvements on existing medicines. Insulin has seen almost continuous patenting since the early part of the 20th century, when insulin was initially used for therapeutic reasons. Next one. So this slide shows you number of patents granted. This is part of this report in Canada. As you can see, one single company on the last column, Sanofi, got more than 400 patents on insulin. And this has created a major problem in developed countries as well, because people there, they cannot access to insulin. There is evidence of people even dying because lack of access to insulin. And then this is a major example of how these practices are used. But there are so many examples. Next one, please. For instance, in the case of ritonavir is a very important. There is a micro open. Can you please take that? Okay. So ritonavir, for instance, as I mentioned, is a very important product for HIV/AIDS. And the World Intellectual Property Organization produced a report on this. And they found, it's difficult to believe, 800 patents filed in relation to ritonavir, and many of them granted. And there's this report by WIPO does alert that for generic companies, for local manufacturing, this is a major problem, because this is not just one patent around the basic molecule, the active ingredient, hundreds of patents around that molecule that will prevent or make very difficult for generic companies to enter the market, because they have to fight, they have to get these patents invalidated. Otherwise, there will be infringement cases and they will not be able to produce. Next one, please. There are other examples here. Losec, omeprazole, is a very well-known product for acidity. On this product, different ways of evergreening have allowed the company to get protection for over 48 years. The case of Cipranil is also a good example, over 46 years. And in the case of alendronate, an important product as well, over 36 years. This is taken from an official report from Australia, where they have also found this phenomenon to take place. And of course, in developing countries, the situation is similar. In some cases, no reports have been made. I wonder, for instance, if the countries participating in this course, reports like this have been made. But if they are done, then you will find that this situation does arise. Next one, please. Next one, please, Amalia. Okay, then this graph shows the new molecular entities of pharmaceutical use that were approved by the Food and Drug Administration between 1994 and 2024. Then, as you can see, ironically, after the entry into force of the TRIPS agreement, pharmaceutical innovation went down, although the proponents of the TRIPS agreement argue that expanding protection for intellectual property, in particular for pharmaceuticals, will increase innovation. But the fact is that, as you can see here, the innovation pharmaceuticals went down. And then there was some increase. But in any case, if you can see, there are no more than, let's say, 40 or 50 new molecular entities which are approved for pharmaceutical use per year in the United States by the Food and Drug Administration, which has a very high standard. But then if you compare this number with the number of patent filings for pharmaceuticals, you will be shocked by the contrast, because although the number of new chemical or molecular entities, including biologicals, is relatively low, let's say 4,000 or 40, 50, as I mentioned, per year, you may find that the number of patent application pharmaceuticals are in the hundreds or thousands per year. And this is the very reason why the right application of patent requirements is so important. Next one, please. Yeah, and the reason for this is that pharmaceutical companies, in particular, not only them, but because in other sectors you have similar situations, they apply what are called patented strategies, which are very well studied in literature, which is called managing intellectual property. And then the strategy, as you can see in this slide, includes blanketing, which is create a jungle of or minefield of patents. For example, mining or bombing every step in the manufacturing process. Flooding, which is the most popular. The flooding strategy is taking out multiple patents, major as well minor, in a field in connection with one particular molecule. As I mentioned, the case of ritonavir is a good example. 800 patents were applied in relation to one single molecule. And this is the pattern in the pharmaceutical industry. For one single molecule, you have dozens of patent applications which are made. And this applies not only to drugs, which are the outcome of chemical synthesis. This also applies to the case of biologicals, such as monoclonal antibodies and other biologicals. Also there you find this pattern of companies trying to extend artificially the monopoly granted by a patent through this multiple filing of patent applications. So how is this done, and how can this be prevented in a very legitimate manner? And of course, many countries are doing this in order to prevent these practices to prevail. Next one, please. Well, this is done through getting patents around a molecule, around the active ingredient, ibuprofen, just to mention one. Then the company, the pharmaceutical company, in addition to getting the patent in relation to the active ingredient, will file, and in many cases get patents related to the formulation or the dosage form of a particular drug, a particular medicine. As you know, the active ingredient needs to be formulated. It needs to be formulated in a pill, in a liquid, or in a capsule. And there are different modalities of formulation that can be applied. And then companies have tried, in many cases, they have been successful in not just getting a patent on the active ingredient as such, but also on the formulation. Of course, the question here is it reasonable to get a patent on a formulation? Is there anything inventive or not in relation to formulation? If you look at the techniques for formulating any active ingredient, you will come to the conclusion that these technologies are very mature. It would be extremely, extremely difficult to find a formulation, let's say a pill or a liquid form or whatever, which can be considered to be inventive. Therefore, if patent application is made in relation to formulation, there is a very strong assumption that inventive step does not exist. There may be novelty because there may be a new formulation. Novelty is not a difficult standard to be overcome, but it will be very difficult to show that there is an inventive step when you formulate a drug, even a biological drug or a drug which is the outcome of chemical synthesis. If we have participants who are familiar with pharmaceutical techniques, I think they may confirm what I'm saying in terms of the maturity of the methods in order to formulate a drug. The same applies to salts. When you have a drug in a liquid form and you want to get it in a solid form, you produce a salt. Producing a salt is again a very mature technology, is very well known. It's just a mix of basic and acid, and you get a salt. And it is very well known what kind of compounds can be used in order to get salts, which are called pharmaceutical acceptable salts. So there is a list. Therefore, for a pharmaceutical company, it's not difficult at all to look at this list and to check and find which is the particular salt which is the most suitable for a given molecule. Maybe a bacillate, for instance, as it was the case for amlodipine. But again, this may be new because in fact, the company may be developing a new salt, but it will be extremely difficult to show that there is inventive step because it's routine, is very well known for anyone working in the pharmaceutical industry how to get a salt in order to produce and market a particular pharmaceutical. Therefore, if the patentability requirements are applied in a rigorous manner, salt should not be patentable. Process of manufacture, there are many patents that do not relate to the product as such, but the process of manufacture. Again, there it's important to look at the novelty and whether, if there is a claim that a new process for manufacture is presented, whether there is a real inventive step. And in many cases, this, again, is very difficult to prove. In other cases, what patent applicants do is to combine two existing drugs, to existing medicines, and to claim that this combination is new, inventive, and deserves, therefore, protection. This may even, this can be made even in relation to drugs which are already in the public domain, meaning that the patent has expired, or even for drugs for which the patents are about to expire. And therefore, by making combinations, then the companies tend to extend the monopolies and prevent other companies from manufacturing and selling generic products. Then here in the area of combination, is what is crucial is to establish whether the combination which is claimed actually proves that there is any synergistic effect among the drugs which are combined, or just they are just doing the same, but you are taking them in a single pill, because this is a possibility. And doctors, when you go to the doctor, in many cases they will say, you need to take two medicines. You take medicine A and you take medicine B. This is very common. Then the company, following what the practice by doctors, they will say, okay, why don't we combine medicine A and medicine B, and we sell them together in one pill? But this will not be inventive at all. There may be a possibility of considering that inventive step has been met when there is a synergistic effect in terms of the combination. So it's not just getting the same effect when they are used in combination. I will refer later on to polymorphs. Optical isomers is another case in which what is done by the companies is to use a very well-known property in chemical compounds. It is known that chemical compounds, they may contain what are called two isomers, what are called optical isomers. And then what the practice is the companies first get a patent on what is called the racemic mixture. That means the patent will not identify any of the optical isomers which are contained in a chemical molecule. So we get a patent on the whole, which is called racemic mixture. Then some years later, the same company comes to the patent office Can you hear me?
Yes.
Okay.
Yes, we can hear you.
Yeah, apparently it has. Then, in the case of the optical isomers, after some years, the same company comes to the patent office and say, now we have isolated one of the isomers in this chemical compound, and then they will claim that there are surprising elements, properties in this isomer, and they will then try to get another patent on one of the components of this molecule. But then again, it is very well known for those working in pharmaceutical industry that isomerism does exist, that this property for molecules to have different optical isomers is there, has been known for decades. And therefore, it is very well known for anyone in the pharmaceutical industry or working in university or teaching chemistry that this situation does exist, and there is nothing inventive. It's just isolating one of the isomers and trying to get a new patent. And therefore, this is another case in which if the requirements of patentability are applied in a rigorous manner, there will be no reason whatsoever to grant a patent. Okay, but these are some examples of how evergreening takes place and how these patent thickets of hundreds of patents are made just by not only getting a patent on the active ingredient, which will expire, but getting patents on formulations, salts, combinations, polymers, optical isomers, so on and so forth, in order to extend the term of protection beyond the expiry of the original patent. The question is whether these additional patents are worth granting. And in our view, and in the view of many scholars, and also many patent offices, there is no reason whatsoever to grant a patent on these, in some cases, improvements, developments, derivatives, which are routine, which can be done by anyone with ordinary knowledge in the pharmaceutical industry. The problem is that, as I mentioned before, that some patent offices do not apply the patent requirements in a rigorous manner. In particular, if they follow what the United States Patent Office does, they will make this mistake because the US Patent Office is very well known because of these very lax standards for patentability. If we had time, I could show you some examples of patents granted in the United States, but you could see that inventive step is not there. One professor from Stanford University used to say, Professor John Barton, used to say that in the United States, the requirement of non-obviousness, which is equivalent to inventive step, actually has disappeared in the examination process of the patent office. They just look at the novelty, and if it is novel, then the patent will be granted, but it has been a very low standard applied. Therefore, that's not a good model for countries that want to encourage local production and countries that want to encourage and enhance access to medicines. For the United States, it is up to them, they decide their policy. But for countries, developing countries in the Caribbean, in Africa, in other developing countries that want to comply with the patent law, because I'm not arguing here for ignoring the patent law at all. I'm just arguing for applying the patent law in a manner which is consistent with its original objective. And the original objective of the patent law is to promote and protect innovation, not just to allow commercial practices that prevent legitimate competition and manufacturing, and therefore access to drugs at affordable prices. Then this is a matter of patent policy. And one point I would like to stress is that it is up to every country to decide what kind of patentability standards are applied, because as we will see, the TRIPS agreement does require to grant patents when there is an invention, novelty, inventive step, industrial applicability, but the TRIPS agreement does not define these requirements. In the national laws, you also have in general reference to these requirements, but there is no specific definition of them in terms of the standard, for instance, for inventive step, which is generally related to the knowledge of an expert in the field or a person with ordinary knowledge in the field. I'm going to refer to this later on. But then the important point is that there is policy space to design a patent policy that will allow for, will give room for local manufacturing to the extent that these patents around a chemical compound, hundreds of patents in some cases, are not granted. And if they are not granted, you are just complying with the very intent of the patent law. You are not breaking the patent law. if patents on, let's say, formulations, salts, or polymorphs are not granted, this is fully in line with the very intent of the patent law, which is to promote innovation and not just to facilitate commercial practices that will limit competition, exclude competitors, and prevent local manufacturing, and through this then, of course, have a negative access in relation to negative impact in relation to access to medicines. So now let's move to the next one. And Amalia, please. Amalia, can we? All right. Okay. Then, as I mentioned, you're familiar already with the TRIPS agreement. And if you look at the Article 27 of the TRIPS agreement, you will see that there is an obligation to grant patents when there is an invention. But interestingly, in the TRIPS agreement, there is no definition of what an invention is. If I would ask you whether there is a definition of what an invention is in your national laws, the most likely reply I will get is that your national patent laws do not define invention. Interestingly, the concept of invention is not defined in most patent laws around the world. Very few laws contain a definition of what an invention is. One case is the Mexican law, another case is the Argentine law, which actually followed or almost copied the Mexican law. There are some other laws, but very few laws define invention. Check whether the national invention you have a definition of invention. Therefore, this means that under the TRIPS agreement and also under the national laws, there is a significant policy space for patent offices to decide what's the scope of this definition. And I'll give you one example. Is a gene which is isolated and for which a function is found an invention? So let's say that through scientific activity, it is found that a particular gene produces a certain effect. For instance, a tumoral effect, it produces a tumor. Then can you go to the patent office and then submit a patent application saying, I have found that... yeah, can you please close that micro? Abdallah, there is a micro. Can you close it down? Then if you go to, thank you. Then can you go to the patent office and they say, I have found that a particular gene has a function, X, and then you claim that gene in an isolated manner. Will that be an invention? Well, I would like to have your replies, but we have no immediate access right now. But the reply in the United States was, yes, this is an invention. And then thousands of patents were granted in the United States on isolated genes for which one function was identified. And a set of patents were granted in relation to gene, which is considered to cause breast cancer. And these patents were granted to a company, Myriad. Then the Myriad company owned the genes, and then any test in order to identify whether a particular woman would have this gene was subject to the patent of Myriad, and therefore it was very costly. And because of this, a number of institutions, including the Institut Pasteur, they started litigation in the United States, arguing that it was not really possible under the United States law to consider that a gene, just because it is claimed in an isolated manner and for which a function was found, to be considered an invention. And this led to litigation, very interesting litigation. In the first instance, the the judge considered that the patents owned by Myriad were invalid. And then the judge said that the fact that the claims in the patent said isolated gene, meaning that was different from nature. He said this is just a lawyer's trick. It doesn't make any difference whether the gene is claimed as isolated or not. The gene continues to be natural, continues to be part of nature. And then, interestingly, the US government, at the time Obama was president, through the Ministry of Justice, they made a submission in this litigation. Then, as you can see, they say the chemical structure of native human genes is a product of nature. And it's no less a product of nature when the structure is isolated from its natural environment than are cotton fibers that have been separated from cotton seeds or coal has been extracted from the earth. This means that the US government, through the Department of Justice, actually supported those that considered that these patents were invalid. But then it's interesting because it shows that the same concept may have different interpretations. Because as I mentioned at the first court, the decision by the court was these patents are invalid. But then this decision was appealed, and the Court of Appeal of United States that deals with intellectual property, which is very well known because it's really very much pro-patent. Then this court said, no, the judge is wrong. These patents are valid. Then, as you can see, even within the country, you had two interpretations about what the concept of invention was, because in the view of the Court of Appeal, the fact that the gene was claimed in an isolated manner was sufficient to consider different from nature and therefore as an invention. Then this case went to the Supreme Court of the United States. And the court made the decision. Next slide, please, Numalia. And then the Supreme Court in this case said that the naturally occurring genes, even if isolated, are not a valid patentable subject matter. They joined the opinion of the first instance. The name of the judge was Sweet, who considered that just the fact of saying that the gene is isolated does not mean that an invention has been obtained. Then the Supreme Court actually considered that these patents were invalidated. Then the court also made a decision or an obiter dictum saying that although DNA as such or genes as such are not patentable, what is called complementary DNA may be patentable. So complementary DNA is the instrument that biotechnology used. They don't use DNA as such, but they take out what are introns which do not express any proteins. So the Supreme Court made a distinction which for many scientists is not really reasonable, arguing that in the case of cDNA, complementary DNA, patentability may arise. But of course, for our own countries or countries which are participating in this course, it will be up to the patent office in the first place, and secondly to the courts, which in the end will make the patent policy to decide whether you might consider or not that an invention exists when a gene is merely isolated. Next one, please. Just to show the differences that do exist, then if you go to the European Directive on Biotechnological Inventions, and you have here Article 3, Paragraph 2, then you will see that in Europe, now, unlike in the United States, a gene which is isolated may be patentable. So this provision says biological material which is isolated from its natural environment or produced by means of a technical process may be the subject of an invention, even if it previously occurred in nature. Then in Europe, you have the paradox, because the European Biotechnological Invention Directive initially aimed at follow the US policy in order to have the same level of incentive for biotech companies to work in Europe. But then now you have this paradoxical situation in which patents which will not be allowed in the United States may be allowed in Europe. But this is a good example about the flexibility that is actually given because invention is not defined, neither in the international law, in the TRIPS agreement, nor in the national laws. Next one, please. Nirmalia, next slide, please. And then, for instance, if you look at the Brazilian law, the Brazilian patent law was adopted in 1996. This is one of the few laws that actually makes it clear that there is an exclusion from patentability of living beings or biological materials found in nature, even if isolated, including the genome or germplasm of any living being. Therefore, in Brazil, for instance, as you can see, it is in the law itself, the fact that a gene, even if isolated, or any other biological material, even if isolated, is not subject of a patent. It's not a valid subject of a patent. So this is just to show flexibility in this regard. Next one, please, Nirmalia. So now I'm going to move to another issue that was presented in a previous slide, but I had not developed, and these are polymers. I don't know whether you're familiar with the concept of polymers. Let's move to the next slide. Okay. So the situation is as follows. When you have a chemical compound in a liquid form, and then you crystallize the compound in order to get a solid form, and you get crystals, you do this through a crystallization process that usually you need to use a solvent, you need to use a certain degree of temperature, so on and so forth. Then you crystallize, then you get the liquid shifts from this form to a solid form, and then you get a crystal. But then surprisingly for many, when you apply different crystallization processes in terms of the solvent, in terms of the temperature, in terms of the speed of where you put the temperature up or down, so when you change in some way or another the crystallization process, but always the product is the same. You only change how you crystallize it. Then you will find that the final crystals may have a different atomic structure. You have exactly the same compound, but the atomic structure, the way in which the atoms are organized in the molecule change. Then for one single medicine, for one single product, you may have one or two, three, four, even 8 polymers. It means that for one particular molecule, you may have different polymers, different polymorphic forms, which are generally called alpha, beta with Greek letters. So just for you to see in this case, this is a chemical compound. This is one polymer of the chemical compound. Nirmalia, if you can please show the next one. Then you see the same chemical compound was crystallized with the differences in the crystallization process, and you get this structure, atomic structure. Then what's the difference? The difference is that some of these atomic structures are not very stable, and some of them are stable. Some of these structures absorb more water or less water. So there are different physical or physical-chemical properties. But the active ingredient remains the same. The therapeutic effects of the ingredient are the same. What changes is the stability of the molecule and some physical properties of the molecule. Then now, Rimaria, if you can go up to this, yeah, go up again. This one, okay, thank you. Then the question here is the following. Since everybody who has made studies of chemistry, organic chemistry, everybody who has worked in the pharmaceutical industry knows that polymorphism does exist, that he or she knows that when you crystallize, the molecules that you get may have different atomic structure, and this is a fact. Given that it is known that these atomic structures may have different stability, in some cases they are very, very unstable. They may even last for a few minutes and disappear, but some of them are stable. Given that you know all this, can we consider that finding a particular polymorph is an invention? Then you can have here two approaches. One is to say, and this is the approach followed by some patent offices, for instance, in my own country, in Argentina, where they consider that since the polymorph is an inherent property of the molecule, you really don't invent anything. You find the polymorph. Because you crystallize, and when you crystallize, you don't know what polymorphs you are going to get. You don't know what atomic structure will emerge when you crystallize the molecule. So it's not up to you. It's up to the inherent characteristic of the molecule. Therefore, one question which is critical is a polymorph invented or is it just found? Then for some patent offices, a polymorph is just found, is not invented, and therefore no patent can be granted. Let me tell you, however, that when the polymorphism was discovered by the pharmaceutical industry as a new methodology in order to get new patents, it was extensively used by the pharmaceutical industry. Then thousands of patents were filed, not just on the active ingredient as such, but on a particular polymorph, generally the most stable polymorph of an active ingredient, precisely in order to evergreen. Then when the patent on the original molecule was about to expire or a few years before, then a new patent application will be submitted in relation to the polymorph. If the patent is granted, then the legal monopoly, which is granted by patent, may continue for 20 years or whatever the remaining time is. Then has been extensive use of polymorphism in order to do evergreening. Then the question is, as I mentioned, is it an invention or not? In some cases, in some patent offices, they say this is not an invention. Therefore, there is no question whatsoever whether it is novelty, inventive step, or industrial applicability. Once it is determined that there is no invention, you don't need to go and examine whether novelty, inventive step, etc. does exist. The issue is finished. Then this is one approach. The second approach, which for instance is applied even in the United States, is to say, well, there may be an invention, but since it is very well known that polymorph exists, and it has been known for more than 100 years now, it is very well known that polymorphs exist. There is no possibility to have an activity of inventive nature just to find which is the most suitable polymorph for manufacturing a product. So let's move Nirmalia down, please. Next one. Okay, here, no, the previous one. Yeah, here. This is a decision from the Court of Appeals of the United States, which I mentioned before, which as I said is in general very much pro-patent. But in this case, the court said by the early 2000s, skilled artisans would have appreciated that drug products preferably contain a compound's most stable polymorph, because metastable polymorphs may convert during manufacture or storage. Then even in the United States, now it is accepted, as you can see in this jurisprudence, that polymorph is very well known. It is very well known industry. It's routine. Actually, it's routine for any industry. Once they have produced a new chemical compound for pharmaceutical use, it's routine to look for the polymorph, which is the most suitable for manufacturing. And you know why this is the case? Because polymorphism is such that a polymorph, if it is not stable, may change naturally without human intervention and move to another form. This was the case, for instance, of ritonavir. Ritonavir that I mentioned before, for which 800 patent applications were made. Ritonavir is a case in which the company did produce ritonavir. They put the product on the shelves, and during the time the product was on the shelf, the product changed because the initial polymorph was not stable. And therefore, a new polymorph may arise even without human intervention. And this actually is a strong argument in relation to the view that a polymorph is not invented, because even naturally the polymorph may evolve and a different atomic structure may appear. Just putting the product and leaving it for 3 months or six months in the shelter. Okay, so let's, I hope this is clear. I hope this is not very complicated technically. I think, Nirmalia, we still have just 5-7 minutes. Maybe it would be good to leave this short time for questions, if there are.
Thank you, Professor Correa. Yes, indeed, we have about 10 minutes left. So before we proceed further, and we have a session tomorrow, colleagues, if you have any questions on the presentation so far, and also from the previous modules as well, you can raise it now. Thank you. Miriam?
Yes, thank you so much, Professor Correa, for your very clear presentation. I come from a small Caribbean country. If I have to only think about examining 800 patent applications, I think we will never be able to do that. How do you limit the frivolous patent applications when you're in a small country and you're forced to, or you're finally trying to get TRIPS compliant, or you're forced in being it? Thank you.
Well, thank you, Miriam, for this very excellent question. I think one way of preventing frivolous patent applications to be filed is for the patent applicant to know that the patent office is applying rigorous standards of patentability, because this will immediately mean that they will abandon the idea of filing patents for which they know there is no real future. And I reply this on the basis of experience. So the countries that have developed and made known rigorous standards of patentability, they receive much less patent filings as compared to other patent offices. In which, because the patent applicants, they will just know that if the examination is lax, they can get the patent in any case. So if you compare, for instance, the number of patent applications received in some African countries in South Africa, where there is no substantive patent examination, for instance, you will see that many patents which are filed there are not filed in other countries. Therefore, my reply would be one way of doing this is to make known, for instance, by developing and making public guidelines for patent examination, which are TRIPS compliant with your law, but which are rigorous in terms of scientific knowledge, in order for patent applicants to know that there is no chance for them. If they want to try, they can, but there is no chance for them to get patents on frivolous developments, such as a simple salt, a simple formulation, or a polymorph. The second method was applied in Ecuador for some time, and this was to increase the fees for patent applicants. And you can have exceptions for small companies, you can have exceptions for universities, and so on and so forth. So there is nothing in the TRIPS agreement, for instance, that will prevent you from having different fees for patent applications, considering whether it's a big company, or a small company, or national company, or whatever. But then this was also very effective in the case of Ecuador to reduce the number of patent applications, because they really applied a very high fees, and they also applied fees taking into account the number of claims. So the larger the number of claims, the higher the fee to be paid, and in some cases would reach thousands of dollars, dozens of thousands of dollars. It was very high. So these are two methodologies that may be applied, and also higher fees may be good in order to finance the activities at the patent office in the country.
Thank you very much for your answer.
Thank you. We have James Jalla and then Jessica, please.
Thank you, Professor, for the presentation. It provided much more clarity to the readings we've been having recently. But my question is actually directed at SoftCenter. I'd like to know how to access the live session recordings. I missed the last session, and I've been struggling to access the recording. Thank you.
Thank you. We will get back to that and put that up for your reference and noted. That's well noted. Thank you so much, Jessica.
Hi, thanks so much for the presentation, and thank you, Professor Correa. I would like to ask, more than an ask, is a reflection on the points you were mentioning, particularly if countries are looking to support also the development of their local innovation capacity and strengthening their let's say R&D and connecting that with the productive sector. So I've been working many years supporting that in developed and developing countries, and one of the things is how for example, create the capacity locally. We were just asking recently about that the offices can have the kind of having to leverage the field, if we could say, in terms of having the capacity also to assess those applications. And also we know there are a lot of incentives that are actually, for example, I work very closely with the technology transfer offices of universities, and they're really incentivizing for more and more patent applications, as it is part also of the accreditation of many of those universities in order to get funding from public agencies and so forth. So I think there's a kind of a trade-off in understanding the purpose of, as you well say, of the IP and beyond the patent, of course, the IP as a strategy, and why we're using this in the context of innovation as well as the different national priorities that we could have, for example, in terms of health technology access. So in other words, we could ourselves be kind of blocking of the opportunities of, as you say, startups or spin-off from universities by being using the rigorous that is not used in other countries. But at the same time, and I am a witness of that, many of the technology transfer offices are also being capacitated in the what is called the gold standard of innovation hubs that are particularly in the US or in Europe, for example. So it's a thing of a kind of understanding how we from the South, for example, the global South, can also anticipate and position ourselves and understand the role of the IP in the whole innovation strategy and the national development. So I just wanted to point that out because I know many colleagues of mine are really looking into this and they see the US as kind of a kind of gold standard in that. I've been working a lot in the UK and I advocate not necessarily to look always into those as a reference, but understand our local reality. So I just wanted to point that out. Thank you.
Okay, well, thank you for the question. You have made a very important point. So there is such a flexibility in the patent law, in particular with patent requirements, that this gives the opportunity to align the patent policy with other national policies, with public health policy, industrial policy, agricultural policy, and this is very important. It's very important not to look at the patent policy as an isolated policy, but look at it as one that must be integrated, fully integrated, must be fully integrated into, my God. Can you hear me?
Yes, we can hear you.
Okay, so it must be fully integrated into the national policies. Then your question is very relevant, and one question would be, if we apply rigorous standards for pharmaceuticals, can you still hear me?
Yes, we can.
Okay. Because the screen is moving, it's very unclear. If you apply rigorous standards for pharmaceuticals, will this discourage some kind of innovation in the country? I would say the reply is no. In the first place, you can apply different standards in other sectors, in the engineering sector, in the electrical sector, electronics, whatever. So there is, of course, these standards will apply what I have referred to pharmaceuticals, an area in which you will not expect Caribbean or African countries, today at least, to develop new drugs, fully new drugs, maybe to make some improvements, but in our country, we don't have the capacity to innovate in terms of fully new drugs. And therefore, this policy will not affect in any manner the use of the patent system in other areas in which innovation may be important for a particular country. Another discussion is whether just having low standards of patentability, as it is the case of the United States, is positive or not for promoting innovation. If you look at the literature in the United States, you will be shocked because many scholars, and there are books published on this, we can share with you some bibliography, that argue that actually the way in which the patent system is applied in the United States has a very negative impact on innovation. It's not really positive for innovation. And this is, I would say, is the prevailing view among those scholars that study patent law in relation with innovation. Because as I mentioned at one point, the very purpose of the patent is to promote genuine innovation, real innovation, real technological change, or not just minor improvements. And the overwhelming number of patents which are granted are not in relation to breakthroughs, in relation to new products, new technologies, are just improvements on existing technologies. And in many cases, unfortunately, trivial improvements. So therefore, I think there is a lot of room in order to align the patent policy with the with innovation policy of a particular country. But this will not mean to dismiss the idea that in the case of pharmaceuticals in particular, if you want to have local manufacturing capacity and enhance access to affordable drugs, you need to be rigorous, to apply the patent system in the way in which it is intended to work, to promote innovation, to protect innovation where it does exist. The problem is that in this area, there are many patents which are filed, as I've tried to show, in which there is no real innovation. It's just using the system, abusing the system to prevent competition, to prevent local manufacturing. This is the aim. It's not really to protect innovation. All right, well, I think we have now passed the time. Sorry for that.
Thank you, Professor Correa, and thank you, dear colleagues, for your participation in the live session today. The session has been recorded and the recording will also be made available. I'm just checking if there is anything in the chat function. Yes, there is one comment from Miriam. Although smaller countries have very limited R&D capacity, we have a lot of traditional knowledge which at times is exploited. That is very true. And this is a related discussion that happens also in related fora, including in WIPO and in the TRIPS Council, is on introducing a mandatory disclosure requirement about source and origin of traditional knowledge used in patent applications. So with that, colleagues, I would like to again thank you for participation in the live session today. I would assume that you would have a number of questions going forward, which you can again raise to us through the Q&A function on the platform. And we would be also happy to explain this more if you need a little more explanation in the live session tomorrow on these elements as well. There are a number of other technical aspects to be covered in tomorrow's session. And I would strongly encourage all of you to come back and join us again tomorrow, being a Friday for this session. Thank you very much, and I wish you a pleasant rest of the day or evening, depending on where you are in your respective time zones. Thank you very much.
Yeah, bye-bye. Thank you. See you tomorrow.
Bye. Thank you.